Hi everyone. 3 green card holders were denied and they could not enter the United States. It's a hard day today. I'm driving back from Mexico. I was there, I was trying to liaison, I was trying to petition, I was trying to do my best to try to get them in, talking to the different officers, but it just didn't work. And I just want to share the things, the takeaways, because what used to work is not working anymore. It's a very clear sign that things are changing down there, and there's so much that I want to share, so let's get into it. Okay. Three cases, 3 separate families, completely unconnected with each other, each case more sympathetic than the next. The first one, this client's been out of the US for 8 years, didn't know he could come back, his green card is expired, he has a minor criminal offense from 10 years ago. All 3 of these compounded together made the officer just shake his head. All right. So if it was purely been out of the US for 8 years, we just did a case just like this 2 weeks ago. The officer said, I understand. I understand the excuse and the reasons and the proof that he's going to live in the US. You prepare the documents well. We let them in. That was the client from 8 years ago, a couple weeks ago, been out of the 8 years. But because 10 years ago there is a criminal offense that it's on their record, even though it's minor, even though case been dropped, but the officer is just much more reluctant to even grant this approval, right? And yes, green card is expired, but so many people's green cards are expired. So many people's 551 stamps are expired. They can still try to get the I-193 waiver of travel document. Heck, I was in line today and there were so many people that I saw with my own eyes that just walked up and with no document, no passport, no green card, no visa, and explained that they have a right to come in, and they get pulled into secondary, get processed, and still enter, right? I mean, US citizens who lose their documents, things get stolen and they try to come back in. You get pulled into secondary, they pull your background, you have lawful permanent resident status, and they permit you in, right? So losing and having expired documents is not that big of a deal at land borders. Being out of the US for 8 years is a much bigger deal, but again, they have a really compelling reason and they have proof that their US citizen spouse and children are here in the US. But none of that worked just because of that one extra factor of a criminal offense that had been dropped 10 years ago, right? It was a hard case to start. I understand that, right? Totally get it. Because if you've been outside for 2 years, a lot of officers don't even let you in, let alone 8 years. But because we have been so successful in the past 2 years, getting people in, even if they're out for 8 years, 9 years, or 13 years, but because of these multiple compounding factors, expired documents, 8 years, plus the criminal offense, it made this case just that much more difficult. So the advice is try to get them the 551 stamp, which we are trying to do. And if we can get that, at least it solves the problem of having an expired document. Trying to get 551 stamp, we're trying to get a new I-90, and we'll see if the clients can come in. If it's just the biometrics, they won't accept it. I was here just a few weeks ago. Clients having a biometrics used to work the past few years, but now, not gonna fly. 551 stamp proving that you are a lawful permanent resident, you have an entry document, an added stamp. That's what they want to see now. So the first client was a hard no. The second client, case is even more sympathetic. The child's been out of the US for about 6 years. The documents are expired. Their 829 case is pending. Okay, yes, it's hard, but based on those fact patterns, we've successfully helped so many different people come in. But here's this one additional nuance that caused the officer to shake his head and said, no, deny them entry. And it's the fact that 2 weeks ago, They had tried to enter by themselves at the Canadian border, and they've been denied and turned away. And because of that one fact, the officer said when they look into the system, they see that they've been turned away, and another officer, another superior officer, wrote they have to enter with an SB1 visa or a new green card. Now, were they serious? Why did they write that? Is it just a grammar issue? Is it like, for sure you need it? Or is it just like, oh, they have expired documents, so I'm putting it in there? The point is, the officer here in the Mexico border did not want to override the Canadian border officer's decision. Now, we spent over 2 hours talking about this, right? Because the client, they couldn't get in, so we had to take them back to the hotel. They checked back in. We're trying to find another solution. And then I went back and I sat down with the officer to talk about this. The officer said, look, in the past, I did override other officers' decisions. But that is if there's clear, convincing proof that the officer was wrong, right? Maybe the client went and didn't provide enough documents. So with enough documents, they could override it. Maybe if the client's misspoken and there was a miscommunication and there's a misunderstanding, or maybe the officer didn't see the green card, thought they were a tourist because they used the wrong passport. Whatever the situation, if there is a way to override the other officer, the officer would do that. But in this case, the client's been out for over 5 years. The 829 is still pending, and all the documents are expired. So the other officer did not make a mistake. Typically, in this situation, you are required to file for SB1 visa and get it to come back in, or you need to have an actual entry document. Humanitarian parole is no longer being issued very easily, because if it could, that's what we will be requesting. But the CBP officers are not willing to grant humanitarian paroles to let clients enter to get their 551 stamp and then come out, right? Because if they can come in with a humanitarian waiver, get the in-person interview, 551, then it proves that they have a green card, then they can re-enter again and saves the whole thing. But they're stuck in this catch-22. They cannot enter, they cannot apply. What are they going to do, right? So because of this one additional fact that the client tried to come in by themselves and another officer denied them, the officer was not willing to let them in. So the clients had to go back to Mexico. We had to physically go back with them. It's insane, because just last week, I was meeting with the officer about this case, and they were reviewing everything, and it was fine. But later on, today, when we were entering, when they're pulling the record, they saw that adverse notation. And because of that, it cannot proceed. Everything else was fine, right? Expired green card, not a problem. Expired documents, they have a biometrics coming up. We understand. We're willing to let them in. The mother even flew with the child to come and do this, but was just not willing to let them in. So the solution now, and we don't know if it's going to work. The solution is to file an emergency 551. I'm actually driving to the Santa Ana field office right now to see if we can get that emergency 551. And if we get it today, if we get it tomorrow, the next day, then I could take it and get it on behalf of the client, go back down to Mexico, and then bring them back in, right? Because essentially, here's the argument. The officer will be able to say, because of this 551 stamp, your circumstance is now different than 2 weeks ago when you try to enter through the Canadian border. Because of that, now we're able to let you in. I'm able to override that other officer's decision, right? So we have to get this new additional thing. And a biometrics doesn't work because we already got the biometrics. Because through the officer, anybody could get a biometrics appointment. It doesn't mean you have proof of your validity to come to the US. So that's the game plan for the second client. Go to the field office, try to get an emergency approval for a 551. If we can get it, then we can hand deliver it to the officer, pick up the client, and come back in. And if we can't get this 551, then the client is stuck. They can't come in. At least there's no other way that we know in which they can come in. Their 829 is going to get denied because they missed the biometrics multiple times. They're going to have to do a motion to reopen, and they're going to wait maybe another year plus. Now they've been out for the U.S. for 6 and 7 years. And then who knows what they're doing at that time, and if they, to see if they can come back in the future, right? But that's like really hard at that time. And the third case, which I think is the most sympathetic, the client entered the U.S. with a green card. The officer confiscated it and said, you have a notice of intent to appear, but you don't have to, we're not going to detain you, but you have a court trial in 6 months, right? So this is like next February, 8 months, right? They're going to have a hearing. The client could not stay, will not stay. So they left. They got a 551 stamp and they left the United States. Now they want to come back. The officer said, no. If they come back with a record that they have a notice of intent to appear, it is now the policy to detain them. That's crazy, right? You are a green card holder. It has not been revoked yet. Now, it's up to the immigration judge to revoke it. The first time they entered, their green card was confiscated, but they still got the 551 stamp proving that they're able to enter and exit and proof that they have lawful status in the U.S., right? They have all of that. Yet, without knowing, right, they left the United States, and now they want to come back to go to trial. But just because they have an NTA, a notice of intent to appear, it is the policy of customs to detain them and ask ICE to detain them. It is just like a blanket rule now. In the past, we only see this for dangerous criminals with warrants, okay? Like in the past, only people with warrants faced this kind of decision process. Because even if you have like a minor criminal offense, if you demonstrate, if you provide the certified court disposition and you're able to explain that was that case has been dropped, I haven't been convicted, even if I was convicted, it was less than a year, it was not a crime of moral turpitude, I'm innocent. If you're able to explain it to the CBP officer, either at the airport, at the border, or at the deferred inspection, typically the officers have discretion to say, sure, you can enter. But now, even if you're a green card holder and you're entering the United States, but because you have a notice of intent to appear for the trial, in which you're coming to appear for the trial, they will not let you enter free and clear. They will detain you until the trial. Isn't that crazy? Essentially, what I've been told is that CBP's authority, the custom officer's authority, have been stripped away from them. They do not have that discretionary ability to make these choices anymore. Now it's in the hand of ICE. If ICE decides to let them go out on bond, if ICE determines that they can come in, then the clients might be able to come in. Now, I have other cases, that wasn't today, but I have other cases where the clients try to come in. CBP is willing to let them come in, but their hands are tied, so they can't, and so they have to ask ICE. And ICE says, no, we are not willing to go detain them, and we don't recommend you come in. And so now CBP, even though they want to let them come in, they can't come in because ICE isn't willing to come pick them up. Isn't that crazy? But that's not today's case. Today's case is that the CBP officer said, because they have an NTA, our hands are tied. If they fly in, we have to detain them. We have to transfer them over to ICE. And ICE will put them in their detention center to the date of the trial. Now, you can try to apply for bond, schedule, emergency hearing, but you're still stuck there for 10 to 20 days. That's crazy. These are green card holders who are lawful permanent resident, who have the obligation to pay taxes worldwide. They have all the rights and privileges of a lawful permanent resident before an immigration judge strips them of it. Yet, by entering, they have to be detained. They're treated equal to criminals, smugglers, people who are undocumented, people who are awaiting trial. That is absolutely mind-boggling. 3 cases today. The first case, the client has been out for a long time with a small minor criminal offense 10 years ago that had been dropped. The officer would not approve to let them in. The clients retained us to go check. We spent a month preparing the package to go to check, and now we have to go tell the client the bad news that there is a high chance that they will be detained. That's the first client out of the US for 8 years with a criminal offense and expired documents. I understand how the clients feel. I understand the CBP officer. Their hands are tied on that one. It was a hard case to begin with. So if the client chooses to try, there is that chance that they will be detained by ICE. The second, let me go back. If we're able to get a 551 stamp for them, and if ICE decides to not detain them, and maybe just issue an NTA, then maybe they can still come in without being detained. But if ICE says, nope, we have to detain them, the client has to prepare to face trial because of that criminal offense in which he was merely arrested, but the case was dropped. Okay, for most people, it's unimaginable what that means. But that's the first case. The second case, I was physically there with the client, and it was just so sad. The mother, the child, both green card holders, out of the US because they had to study abroad while they were minors, now trying to come in, but because green card is expired, because 829 is pending, but most importantly, because they tried to enter by themselves 2 weeks ago and got denied when the other officer wrote this demerit on their system. Now, the next officer can't even help them even if they wanted to. So the solution to that case is, right now, I'm trying to go to Santa Ana. I'm trying to get them emergency 551. If I can get it, then we can override the Canadian officer's decision so we can come back in. Third case, client is out of the country, already came in, but got everything taken away and has a notice of intent to appear. They have to face the possibility of ICE detaining them. It is completely out of the officer's hands. This is just a nightmare upon a nightmare for so many people. You think after all these years and after all this hard work and after all this investment and after all this tax filing and paying taxes, lawful permanent resident green card holders would be treated better than when they had a tourist visa. But now, seemingly, green card holders' rights and privileges are just being stripped away left and right. I mean, the only safe way is just to stay in the US. At least maybe ICE won't come and directly deport you unless you're I don't know, not in line with the political affiliation of the current president in power. Doesn't that sound like an authoritarian state? I can't believe I'm even saying this. I am extremely disappointed today. And I understand not every case can be successful, but we've already done everything we can to try to make it as smooth and as clean, as good as possible, right? For the first and third case, we prepared so many documents to come to try to present and argue. The second case, I literally came last week to talk to the officer and getting the clear, yes, come. And even last night, the client was stressing. I said, just go to sleep, no problem. It's going to be fine. The officer already said good. But this morning, when they're being inspected, they saw that demerit. Like, an officer says, I can't override that. I can't override that other officers because there's no change. I mean, what is the client supposed to do? So now they're waiting in Mexico, and I have to try to make the impossible possible, right? Normal 551 stamps, the clients are supposed to be in person. It's supposed to take like a week or so. I'm just showing up and trying to make the plea happen. Anyways, when there's more further updates on these cases, I'll let you guys know. You know, I guess when I make success stories, I'm sitting in the office, I'm really happy, but what just happened from 5 a.m. till now, like it's 12 o'clock, it's on my mind, and I just want to share that with everyone. Thanks for watching. Take care.